On February 15, 2017, Oakland County deputies executed a search warrant at the Oakland Township, Michigan home of Joseph Shiley, a tenured business professor at Oakland University. The warrant was based on anonymous tips alleging that Mr. Shiley hosted parties for students involving drug use and underage drinking. 4 young adults were present during the search, including an individual named Jacob Spencer. During the search, officers recovered ketamine along with 2 rifles and 1 shotgun, all of which were unloaded. On February 17, 2017, Mr. Shiley was charged with 7 criminal offenses, including possession of ketamine, maintaining a drug house, 3 counts of possessing a firearm during the commission of a felony, and 2 counts of delivery of ketamine. One of the delivery charges stemmed from allegations that Mr. Shiley had provided ketamine to Mr. Spencer. The case proceeded to trial in January of 2018 in the Oakland County Circuit Court, with Judge Cheryl Matthews presiding. Mr. Spencer was called as a witness for the prosecution and was granted so-called use immunity, which prevents a witness's testimony from being used against them in a criminal prosecution. This allowed Mr. Spencer to testify about potentially incriminating conduct without risking charges based solely on his statements in court. After Mr. Spencer completed his direct examination by the prosecution, defense counsel Neil Rockhind was given the opportunity to cross-examine him.
Mr. Spencer, you have been around people who have used narcotics, haven't you?
Yes.
And you've seen people who, in your experience, appear to be high, haven't you?
Yes.
Who appear to be under the influence of some kind of a drug or affected by some kind of a narcotic, haven't you?
Yes.
Can you look the jury in the eye and tell me whether or not you've taken any narcotics today? Prescription pills, anything of that sort? Xanax, opiates?
Yes, I have taken prescription pills today.
When did you last take a prescription pill today?
This morning.
What time?
I'd say around 9 o'clock.
And what medication did you take this morning around 9 o'clock before you came to court?
I took Vyvanse.
Vyvanse. Vyvanse is an amphetamine?
Yes, I'm prescribed.
Vyvanse is for ADHD?
Yes.
The behavior, the way that you're communicating, and I'm going to speak to you, try to speak softly and have a dialogue with you, okay?
Okay.
The way that you're communicating now, isn't this the way that you've seen people communicate in your own personal life who appear to be high or under the influence?
Judge, I'm going to object to that.
What's the...
Judge, he can ask him if he's high or under the influence, but
I'm not to ask
he's asking him to evaluate his...
I don't understand the question.
Okay.
I don't understand how I could look at myself from a third-person view.
So well, first of all, so the prosecutor objected, Your Honor.
Say the question again, I didn't understand.
Yeah, sure. The way that you're communicating now, I mean, can you hear, I'll withdraw and I'll ask it differently. Can you?
Are you high right now?
No, I'm not.
Okay.
This is the way that you normally communicate?
I don't normally communicate from a stand in circuit court in a case involving an older man that threw parties with underage people providing drugs. I'm nervous. If you're accusing me of being drugs, then you're doing a very bad job as an attorney.
Okay.
You should be asking questions that are actually going to help your client.
Okay, next question.
I appreciate that.
And now I'm angry, and I'm going to tremble my voice even more, not because I'm on drugs, but because I'm nervous. Okay. And you're intimidating. That's what you do.
Okay,
and it's not going to work.
Okay, just answer the questions. And then
that's my answer.
Okay, we'll just answer his questions and we'll get you out of here. Okay. All right. Go ahead, Mr. Rocco.
Thank you, Your Honor. Today, you testified a few moments ago to the jury in response to Ms. Hand's questions that Joe has provided you with ketamine on prior occasions at his house.
Correct.
And you said it was almost, I think I wrote down, said almost every time you were there. You remember that?
Yes.
At the preliminary examination, that was when you testified before in district court. You remember that?
Yes.
And you took an oath at that time, is that right?
Yes.
And at the time that was closer in time to the events of February 15th, true?
Yes.
And you told that time you were asked this question, and this was your answer on page 62. Approximately how many times had you ingested ketamine that the defendant gave you at his house? Your answer, it was one time. It was that night. Wasn't that your answer under oath at the preliminary examination?
Yes, it was.
Today you've told the jury something different, haven't you?
Yes, I have.
So, 2 times under oath, you've given 2 different answers. True?
True.
Both of those pieces of testimony can't be true, right?
Mr. Rockhind impeaches Mr. Spencer by highlighting a clear inconsistency between his trial testimony and his earlier sworn statements. At trial, Mr. Spencer testified that he received ketamine multiple times. However, during his preliminary examination, he testified under oath that he had been given ketamine only once. Impeachment is the process of challenging a witness's credibility, often by showing that their account has changed over time. Under Michigan Rule of Evidence 801D1A, a witness's prior statement is not treated as inadmissible hearsay when 2 conditions are met. First, the witness must be testifying at the current proceeding and be subject to cross-examination. Second, the prior statement must be inconsistent with the witness's current testimony and must have been made under oath, such as during a preliminary examination. Because Mr. Spencer's earlier testimony was sworn and directly contradicted what he told the jury at trial, Mr. Rockhind was permitted to confront him with that prior statement to expose the inconsistency and undermine his credibility before the jury. Before we continue, a quick thank you to today's sponsor, Incogni. If you've ever searched your own name online, you've probably been shocked by how much personal information is publicly available. Your address, phone number, and even details about your relatives. That information is exactly what scammers rely on for identity theft, loan fraud, and harassment. Incogni helps stop that problem at the source. They automatically locate and remove your personal data from hundreds of data broker sites, people search databases, and online directories. And if your information appears somewhere specific, Incogni's custom removal feature lets you submit the link so their privacy experts can handle it for you. One leaked record can spiral into serious fraud. Incogni handles the entire process for you, sending verified removal requests and following up until your data is gone. Right now, Incogni is offering viewers a 60% discount when you visit incogni.com/court and use code COURT at checkout. If you care about protecting yourself and your family from scams and identity theft, check the link in the description and take control of your online privacy today. Thanks again to Incogni for sponsoring this episode.
I'll only keep this yes and no, but I'd like to explain that this isn't about the amount of times that I did ketamine at Joe's house. This is about it goes beyond that. Like I've stated multiple times, I was very inebriated every time that I was at his house. I may have even been given ketamine without knowing it.
You've never told the police before in response to my question. Let me finish my question.
Look.
You'll get every opportunity, Mr. Spencer. I'm keeping my voice very calm. I'm going to give you every opportunity to talk as much as you'd like. But you've never before today in front of this jury made an allegation that somebody gave you ketamine without your knowledge. Isn't that true?
Can you please rephrase the question?
Yes. Until just now, you've never told the police or accused in a formal setting, in this case, Joe, of having given you ketamine without your knowledge, right?
Correct.
That's something new that you just told the jury now.
Well, maybe it was something that I didn't consider when I first stated that I only did it one time.
I'm sorry. I'm moving on to another subject. You're here testifying in court. You understand that, correct?
Mm-hmm.
Yes?
Yes.
You've just made another allegation against Mr. Shield that he drugged you with ketamine without your knowledge. Isn't that true? That's what you just told the jury.
Yes, it is.
Never told that to any police officer formally, nor did you testify to that previously in this case.
I may have mentioned it before. I'm not sure. There were so many times that I talked to detectives.
You just told the jury a second ago that it didn't dawn on you to think about that. Now you're saying that you actually may have said something about that. Those are 2 different things, aren't they?
Do you want me to go back and explain myself?
No, I'm asking you a specific question, Mr. Spencer.
Yes.
So your testimony today includes a new allegation against Mr. Shield that you were somehow drugged without your knowledge?
I'm not saying that. I'm saying that it's a possibility. I'm not saying that that specifically happened. I'm saying it's a possibility, as in there's no way anybody's ever going to be able to know that. I don't even know that myself. I'm just saying possibly, and maybe I considered that when I just said that I took ketamine multiple times at his house. Maybe I considered that it's a possibility, but there's no way I'm ever going to know if it actually happened.
Wait a minute.
That's what I'm implying.
Under oath.
I'm not alleging him of anything.
Under oath, the prosecutor asked you on direct examination whether Mr. Scheel, whether had provided you with ketamine prior to, at the time she went to his house. She asked you that. It was a very simple question. Do you remember it? Do you remember the question and answer a few moments ago?
Yes.
And you said yes. And you said, almost every time I was there.
Yes.
And you're saying that when you told the jury that under oath, that you were thinking to yourself that maybe it was given to me without my knowledge? Is that your explanation for that testimony under oath?
Yes, it is.
Does that make any sense to you? That you would
Yes,
answer
it
a
does
question
make
directly,
sense.
that he gave you drugs in the past, gave you ketamine in the past, but now when I'm questioning you, it's, well, maybe I was thinking of, maybe I was drugged and didn't know it. That's why I answered it that way. Is that really the explanation you want the jury to accept?
I don't know how else you would want me to explain this. I would appreciate if you could move on to the next question.
I'm sorry? You want me to move on to the next question?
Yes.
The questions I'm asking are, Mr. Spencer, pointing out from contradictions in your testimony. Do you understand that? So I appreciate you would like me to move on, but I'm sure you can appreciate that the judge will ultimately tell me when I have to move on. You understand that too, right?
Correct.
Okay. You want me to move on because it makes you uncomfortable to have to getting caught in what is untruthful testimony.
Well, there's a lot of these really small discrepancies, like how many times did you do this? How many times did blah, 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 that like, I didn't just like, this isn't like a test that I studied for. This isn't college. This isn't something that I think is like a huge deal. So when you guys throw all these questions at me and then throw it on the record, it's not something that's like constantly running through my mind every day, and I'm remembering all these little tiny little details and splitting hairs about it.
That's what I'm doing? You think I'm splitting hairs? I'm questioning you about the truthfulness of your testimony and contradictions, and you're telling the jury that that's splitting hairs. Is that what you're characterizing?
I'm giving my time trying to answer all of these questions to the best of my ability.
We'll get to the reasons why you're here later, okay? Do you understand? But I'm still going to put these questions to you. Is that okay with you, Mr. Spencer?
Yeah, ask another question.
Thank you.
Yeah.
You testified today that on February 15th that you drank alcohol. That's what your testimony was under oath just a few moments ago to the jury, right?
Correct.
You were asked this question at the preliminary examination, page 62, lines 18 to 19. Did you drink alcohol that night? Your answer was no, I did not. Correct?
Correct.
Again, your testimony today is different than it was at the preliminary examination when you testified under oath there, right?
Correct.
You told the jury a few moments ago in response to Ms. Hand's questions that she asked you about nitrous oxide. Remember those?
Yes.
She asked you about whether or not you asked you about cocaine being provided to you at Joe's house. Do you remember that?
Yes.
You said that Joe had provided you with cocaine. You said that that was your testimony on direct examination. Do you remember that?
Yes.
That's not true, is it?
Pardon me?
Joe never gave you cocaine, and you didn't do cocaine at Joe's house. That's a lie, right?
Please, can you please rephrase the question?
The question was confusing to you?
No, can you just...
Yes. You testified today that Joe gave you cocaine and you used cocaine at Joe's house previously. That's what you testified to today. You've acknowledged that. I'm putting to you that that is not true. That is a lie. Correct?
That is not a lie. I did use cocaine at Joe's house.
Okay, on page 61, lines 15 through 17, at the preliminary examination where you testified closer in time, the question was put to you, did you partake of the nitrous oxide or the cocaine? Your answer was no, but I've heard and seen it at his house on occasions. Wasn't that your answer under oath then?
That may have been. I don't know. I
Is
haven't.
that both of those can't be true, Mr. Spencer.
Okay, so that was your answer at the preliminary exam, correct?
Yes.
Okay, what's the next question?
Both of those can't be true. What you testified to today to the jury and what you testified to under oath at the preliminary examination, right?
Yes.
So one of them is a lie.
I was lying about not using them.
You were
Because I felt
lying at the
guilty
preliminary
because-
examination.
I felt guilty because my dad was in the room.
At the preliminary examination, you were under, that's just so the jury understands that. You took an oath before you testified in the preliminary examination. Is that correct?
I didn't want my dad to hear that I was using cocaine.
You took an oath to testify to the truth at the preliminary examination in district court, right?
Correct.
You raised your right hand just as you did today.
Correct.
You looked, there was a judge there named Judge Nancy Karniak, right?
Correct.
You looked her right in the eye and answered the question, no. Isn't that true? And you're
Correct.
testifying now is that was a deliberate, intentional lie.
He said yes.
Isn't that perjury?
Well, he's,
Yes, it is.
Okay, I'll rephrase it. You recognize that when you're under oath, you face the penalty of perjury, don't you?
Yes.
You understand deliberately and intentionally lying under oath for any reason is perjury. Do you understand that?
Yes, I do.
So you concede that you committed perjury from your own perspective. By your own words, you committed perjury at the preliminary examination.
Yes.
Mr. Rockhind further impeaches Mr. Spencer by confronting him with another inconsistent statement from the preliminary examination, this time regarding his cocaine use. When Mr. Spencer admits that he lied during that earlier proceeding, Mr. Rockhind argues that the conduct amounts to perjury under Section 750.423 of the Michigan compiled laws. That statute makes it a felony to willfully swear falsely about any material matter while under oath. By acknowledging that he knowingly lied during the preliminary examination, Mr. Spencer effectively admitted to conduct that fits squarely within the statutory definition of perjury. However, despite meeting the elements of the offense, Mr. Spencer would likely not face prosecution. He testified at trial under a grant of use immunity, which prevents the state from using his testimony as the basis for criminal charges against him. As discussed earlier, use immunity allows a witness to testify about potentially incriminating conduct without fear that their own statements will be used to prosecute them. As a result, while Mr. Spencer's admissions significantly damaged his credibility and allowed the defense to portray him as an unreliable witness, the immunity agreement would likely shield him from perjury liability arising from the inconsistencies in his sworn statements.
When the police entered the house that night, you were in possession of drugs, right?
Yes, I was.
And tell us again what drugs you were in possession of.
Xanax.
Xanax. How many Xanax pills were you in possession of?
2.
And you did not have a prescription for those pills, isn't that true?
That's true.
You understood at the time you were possessing that it was a crime to possess them, isn't that right?
Yes, I did understand that.
You understood that it was a serious crime,
Yes.
and you understood that it was a felony.
Yes, I did understand that.
So you knew that when the police entered into the house that night that you were committing a felony.
Yes.
You knew that you were committing multiple felonies if you count the number of pills you possessed. Isn't that true?
Objection, Judge. It calls for a legal conclusion.
I would try
That is
it.
true.
Yes,
I would try it. It's fine.
sustained.
I would try it. I'm asking questions very politely, Your Honor.
He is asking questions.
But you know that's not true.
Well, I don't know. I resent that
Bill.
because I'm not suggesting that I know that that's not true, and I don't like to suggest. You know me. I'm not suggesting
You
any.
suggested to the jury that if you have 2...
I'm asking a question.
Pills, that's 2
You know what? Then
separate pills.
I'm asking a question, and if I'm wrong about that, then I'm wrong about that, and I certainly will withdraw that.
All right,
So-
next question.
So I will withdraw that.
Mr. Rockhind asks Mr. Spencer whether he realized that he was committing 2 separate felonies by possessing 2 Xanax pills, prompting an immediate objection from the prosecutor. Judge Matthews sustains the objection, explaining that the question incorrectly suggested to the jury that a person can be charged with multiple counts of possession based solely on the number of pills involved. Alprazolam, the active ingredient in Xanax, is classified as a Schedule IV controlled substance under Michigan law. Unlawful possession of a Schedule IV substance is governed by Section 333.7403 of the Michigan compiled laws, which makes it a felony to knowingly or intentionally possess the substance without a valid prescription. Importantly, the statute criminalizes the act of possession itself, not the quantity of pills possessed at a single time. As a result, possessing 2 Xanax tablets simultaneously constitutes one offense of unlawful possession, not 2 separate felonies. Therefore, Judge Matthews sustained the objection because Mr. Rockines improperly implied that multiple felony charges could arise from possessing multiple units of the same controlled substance at the same moment, an assertion that misstates Michigan law and risks misleading the jury.
Agreed to testify at the preliminary examination. It was your belief that if you cooperated and testified that you weren't going to be charged in the case. Isn't that true?
Yes, that's true.
And despite whatever it is that you did, you believed at that time that you'll end up with no criminal prosecution and no criminal record. Isn't that true?
That's what I was told.
And who told you that?
That.
Ms. Hand, seated to my right and to your left. And despite whatever it is that you did, you'll end up with no criminal prosecution and no criminal record. That's what you're testifying to. That's what you just testified
granted
to.
Use immunity, I believe the term is.
And you just testified a moment ago that you were told that you'd end up with no criminal prosecution and no criminal record, right?
Well, no prosecution for the possession of prescription pills.
So that's more than use immunity. Use immunity means, doesn't it, as far as you know, that you just get to, your words can't be used against you. But you're telling us that you actually have an understanding that you're not going to be prosecuted at all for your felonies, right?
Correct.
Isn't that in part why you're in here saying the things you are about Joe, so that you avoid a felony prosecution and felony conviction yourself?
Correct.
You're a young person. You're 20 years old, you said? Yes?
Yes.
You want to have a career and a future, right?
Yes.
You have a lot to lose. Would you agree with that?
Yes.
And your participation or involvement in some kind of crime could interfere with that. Would you agree with that?
Yes.
You understood that based upon what you were being told, that if you talked about Joe, you'd be able to avoid being in trouble, right?
Yes.
1 year ago, well, so not 1 year ago, this was back in February 15th of 2017 is when this search of Joe's house took place, correct?
Correct.
And today is January 18th or 19th. 19th, Your Honor? Thank you. In that time, you have not been charged, have you?
No, I have not.
And there are things that you did go down and talk to the police on March 1st of last year, correct?
Yeah, it was around that time.
You got a record deal the day before that, didn't you?
Pardon me?
Didn't you get a record deal? Did you get a...
That makes it sound like he's a singer.
No. Well, aren't you a performer, a DJ?
What does this have to do with...
Well, we'll let the jury sort that out.
Are you talking about this case?
Yes, I am. Yes,
I don't
February
think
28th of 2017, the day before you went down to the police department to talk about Joe, didn't you get a record deal?
Oh, you do mean like singing?
I think a DJ.
I thought you meant, okay, all right.
Didn't you get a record deal? Didn't you get a contract by a company that signed you? Didn't you, something you were proud of?
I'm confused as to why you're asking me this and why you're asking me to disclose personal information.
He's trying to ask you if you have a lot to lose.
So on February 28th, before you went, you talked to the police. You got a record deal. You got a professional music contract. That was something you coveted, that you were proud of.
Yeah.
You understood that a criminal case and a criminal prosecution could interfere with that, didn't you?
Yes.
So the very next day, March 1st, that's when you went down and you talked to the police at the police station about Joe, right?
Yes.
Okay.
On February 24, 2018, following a multi-day jury trial, Mr. Shiley was convicted on 3 counts: possession of ketamine, maintaining a drug house, and possession of a firearm while maintaining a drug house. The remaining charges from the original 7-count complaint were not sustained at trial, including the allegation that Mr. Shiley had delivered ketamine to Jacob Spencer. On March 5, 2018, Judge Cheryl Matthews sentenced Mr. Shiley to a total prison term of 3 to 4 years. Upon completion of his sentence, Mr. Shiley was ordered to be deported to Canada, his country of citizenship. This case illustrates just how pivotal witness credibility can be in a criminal trial, and the lengths to which defense counsel may go to undermine it. During cross-examination, defense attorney Neil Rockhind methodically highlighted multiple inconsistencies in Mr. Spencer's testimony. These included conflicting accounts of how many times he allegedly received ketamine, his admitted dishonesty regarding cocaine use, and his initial attempts to mislead police about his own possession of Xanax. By emphasizing these contradictions, and by underscoring the fact that Mr. Spencer only began cooperating with authorities after receiving assurances that he would not face charges himself, the defense argued that his testimony was driven by self-interest rather than truth. Ultimately, the jury acquitted Mr. Shiley of the delivery charges, including the count based specifically on Mr. Spencer's allegations, while convicting him of possession of ketamine, maintaining a drug house, and possessing a firearm during the commission of that offense. The verdict appears to reflect the jury's nuanced assessment of Mr. Spencer's credibility, shaped in part by Mr. Rockhind's aggressive, though at times imperfect, cross-examination. Let us know if there is a case or courtroom interaction you'd like us to explore in the comments below. Thank you for watching, and don't forget to like and subscribe so we can continue fostering a more informed society.